Hello and welcome to the second recording in our two-part Directors and Officers Risk Management Series of 2020. I'm Millie Mastromatti, Risk Management Education Director at Optima Healthcare Insurance Services. Healthcare organizations are under constant pressure in today's world of evolving practices, procedures, and laws. Managers deal with everything from investment and allocation of corporate resources to administrative duties. The decisions they make affect everyone who has a relationship with the healthcare entity. And it's a huge responsibility. Every action has the potential to put the organization and its individual managers and directors at risk for financial or reputational loss. In addition to all the issues faced by any business, healthcare managers must oversee and direct issues unique to healthcare facilities, such as peer review committees, quality of care, and staff privileges. Healthcare facilities want to hire and retain top talent in the industry to oversee and run their organizations, but need to protect them from having personal liability at stake. Today, our speaker, Attorney Kim Blair of Wilson Elser Law Offices, will explore the possibilities of claims that may arise from those various pressures, and more importantly, strategies to implement for risk mitigation. For information about Kim and Wilson Elser, there's a link in the web links box in the corner of your screen. The other link there is for your evaluation of the program, and we would love to hear your input. Kim, welcome, and I'll let you get started.
Thank you, Millie. As Millie said, the current claims environment for healthcare D&Os is difficult in 2020. There's pressure from investors, there's volatile markets, intensifying competition. In Illinois alone, it seems we have less and less hospital systems to choose from as consumers because larger hospital systems are gobbling up smaller hospitals. There's demanding regulatory requirements on all of you. There's changing workplace dynamics, not only for hospitals and healthcare facilities, but for employers everywhere. And there's certainly shifting customer preferences and new challenges that arise from the COVID environment and telemedicine as we know it today. And with all of these increasing pressures, boards are having themselves increase pressure to design and implement effective risk management capabilities and responses for their organizations in order to decrease exposure to their organizations. And claims, unfortunately, are a cost of doing business for any company in 2020 and previously. However, I'm hoping that these seminars put on by Optima will give you a sense of how you as board members can not only minimize the amount of claims you may see, but minimize the exposure of the claims that you do receive. I wanted to go over today 4 different areas that we're seeing claims against healthcare organizations like those that you all are all engaged in. One of the things that we see often with respect to hospitals and healthcare facilities are claims arising out of regulatory changes and regulatory scrutiny. It will not be surprising to any or all of you that it is a constant battle to keep up with the regulatory changes. I know that I'm married to a healthcare worker myself, who is a director of a hospital, and it seems to be a daily basis that he's watching what's happening in Congress, what's happening on the state level, in order to make sure that they are engaging properly. And so, in addition to what I see at home from my husband, I see from my clients claims and issues arise specifically with Medicare and Medicaid billing investigations. Those also come into play our False Claims Act and key TAM actions. There are whistleblowers in many, many hospital organizations that file claims against the organization and the board of directors alleging Medicare fraud. In the ones that I defend, Not all of those whistleblowers are correct because they themselves don't necessarily understand the intricacies of Medicare and Medicaid billing investigations. But I will say that claims, and when I say claims, I don't mean that they're necessarily successful claims, but claims that are brought against organizations for Medicaid and Medicare billing fraud are expensive to defend, and they suck up a lot of resources for the organization itself. We also see allegations of anti-kickback statute violations. I have a case pending right now in Texas, a key TAM action against a medical practice alleging kickback statute violations. And the expense there comes not only from the litigation itself, but from the government investigation component of that. Stark law violations is something that hospitals have, and certainly board of directors have very difficult time overseeing. These are things, a board of a hospital organization can, I think, have enough risk management in place that they can become aware of, or at least red flag when there's billing problems. Certainly anti-kickback is more difficult for a board of directors to find because you do sit at such a high level, but same with Stark law violations. But when those happen, they are against the organization themselves, and the board of directors is often named, they are often named individually for failure to oversee the governance of the hospital itself. We also see, of course, audits and organizations that voluntarily disclose to the government when issues occur at their organizations. In those cases, there is always an investigation, and it does become difficult and expensive. The second category of claims that we see, not surprisingly, arise out of financial complications for the hospital system. As I discussed earlier, certainly here in Illinois, we see more and more larger hospitals gobbling up smaller hospitals, and that is because those hospitals have gotten into a situation either because competition has become so difficult that their customer base is shrinking, or for other reasons, the board was hopeful that they could grow at a rate in which financially they could not sustain, and they became a perfect opportunity for a takeover from a larger hospital system. And I had a case a few years back. We call them here in Illinois safety net hospitals. They are hospitals in the city of Chicago that service low-income areas. That hospital obtained quite a bit of funding, government funding, not only on the state level, but on the federal level. And the funds that it received were not, or were used to keep the hospital operating. But unfortunately, the hospital got into some serious financial issues, and there was a lawsuit not only by the government questioning the way in which the board utilized those funds, but by private investors who also were questioning the board's use of those funds and how it was paid out. This goes to board's decisions about paying high-level executives, about entering into merger acquisition opportunities, as stated here, using federal funds as designated. It is, again, and hearkening back to the first part of this series, one of the fiduciary duties of a board member is to make sure that you understand the financial condition and that you're making decisions that will not only affect the company today, but are also the right financial decisions for the strategic growth of the organization. If, however, the board has made a decision that part of their strategic plan is to be subsumed by a larger organization, the board of directors would have a different view of its financial wherewithal as opposed to a hospital that wants to continue to operate. And so, hearkening back to those duties and obligations, the board needs to really be on top of its financial health in order to make sure that it's foregoing any potential claims by investors or the government related to financial decisions for the corporation. The third area, again, probably not surprising to anybody who reads the paper, the third area we're seeing an increased amount of claims are claims involving privacy, identity management, cyber breaches, as they call it. In my law firm, we have an entire practice area and a bevy of lawyers dedicated to managing and responding to cyber breaches. It is the wave of the future. And unfortunately and when I say the wave of the future, I should be clear, the wave of the future for the plaintiff's bar. These are claims that they love to bring. They're sexy. They get a lot of press. And they are very expensive to respond to. If any of you have ever had a cyber breach at your hospital, you know the extent to which that can divert resources to managing that cyber breach and the expense of responding to that cyber breach. In addition, I think that healthcare facilities experience additional issues that other companies don't with respect to maintaining the privacy of personally protected information under both the HIPAA laws. There is a significant amount of statutory governance running through various state legislatures about how we are governing telemedicine and what that's going to look like with the onset of COVID and the new uses of telemedicine going forward. So we all have our sort of eyeballs on what that's going to look like in the future. It is, again, we talked about in the first part of this series, the board's responsibility to understand laws and statutes as they apply to hospital systems. And I think that we see in the privacy and data breach and data security area, more than ever, this may be an area in which a board may want to hire a consultant to the extent there are issues with security problems. No one is expecting a board member to be an expert in cybersecurity. However, there are experts out there, and the hospital or healthcare profession is highly regulated when it comes to protecting personally protected information. And last but not least, the claims arising from employment problems are on the rise in healthcare, not only healthcare, I would say everywhere. We have a situation where, and I guess this has kind of been backburnered in the news, but the Me Too movement did create a wave of litigation against boards arising out of sexual harassment claims. I currently represent a board, a volunteer board of very sophisticated, very smart individuals. And 2 years ago, their executive director had a claim of not sexual harassment, but sort of gender discrimination against a woman that was his direct report. The board did what they thought was right, and they had the woman who was making the claim of discrimination, they had her leave the company and paid her a fairly sizable severance. They kept the executive director on. Here we are in June 2020. He now has a second claim by a woman asserting discrimination based on gender and asserting that the board knew about this man's particular propensity to not promote women and to generally make sure that women could not advance in the organization. And so not only is there a claim against the executive director himself, but a claim against the board members for failing to discharge their fiduciary duties and allowing this discrimination to occur. And I will say what's very interesting about representing this particular board is they absolutely believe, and I think in the moment were correct, that at the time they were doing the right thing by dealing with this microcosm of an incident with respect to the woman in 2018. And they never went back and revisited whether or not the executive director's staff was experiencing the same issues that this woman was. And now we're embroiled in a fairly significant piece of litigation arising out of that. And again, hearkening back to our first webinar in this series, you know, you as board members are not required to micromanage your executives, but you certainly are required to evaluate them and to have an understanding of what they do and how they are operating and what the general morale and operational effects of those executives are on the staff in which you are ultimately responsible for overseeing. So in painting that picture of claims, and I don't mean to in any way state that there wouldn't be other types of claims brought against a board, but just in terms of what we're seeing in 2020, really probably the last 5 years, these types of claims are on the rise. And so not to paint a dire picture, because you all are very sophisticated board members, you care, and maybe you're not board members, but your board members certainly care about the organization. So what can we do from a risk management perspective to make sure that we're doing the best that we can? Number one, require routine board reports from your regulatory officer or liaison. Most hospital systems that I've been engaged by have a regulatory officer or liaison. It's important that the board understand what that regulatory officer is doing, what they're seeing, what they're reporting. And again, this goes back to the duty of obedience that we talked about, knowing the laws, obeying the laws, and understanding the laws. You should also obtain regular reports from your CFO. We talked about the rise of financial claims against boards and organizations. It is more important now than ever to understand the inner workings of the financial health of your organization. Again, if there's something you don't know, raise your hand, ask a question, engage an expert. But generally speaking, most healthcare systems have very experienced accountants or CFOs on staff that should be able to shepherd the board through those decisions. We talked earlier in the last session about a succession plan and a perpetuation plan. Again, not only from a financial standpoint, but from an organizational standpoint, to make sure that there are successors to your senior leadership, that the organization can be sustained and continue to run. HR policies, more important than ever. Most organizations have an HR officer or risk management officer. You need to make sure that you have social, things that are new to us, social media policies, and, your anti-discrimination, anti-harassment. In addition, now more than ever, a lot of companies are implementing inclusion, not just diversity, but inclusion policies into their organization. Someone described to me that diversity is inviting a diverse person to the dance. Inclusion is asking that person to dance. I think that's a good way to think about it. Next, just require mandatory training for your employees. Again, hearkening back to the instance I was just explaining to you about a board, the gender discrimination case that I have. There was no required training for the executive director or the board members. And that is going to be an issue that we're going to face in defending the claim that we didn't have any anti-discrimination training for our senior leadership. Establish an incident response plan for a cyber breach or privacy loss. Again, I'm not on the cyber team here at my firm, but I do sit next to them. And when a company has a cyber breach, it is all hands on deck. It is very disruptive to your organization, and it is unruly if you don't have a plan in place to respond to that breach. And again, network security and privacy policies. I'm sure some of you have information technology officers or at least an IT staff. Make sure that you have the appropriate network securities and privacy policies. It's more important than ever for a hospital organization, as we just discussed with telemedicine and HIPAA laws and things of that nature. And as a board, make sure that you develop and implement procedures to avoid potential breaches of fiduciary duty. Make sure you have procedures in place that if one of your board members does have a conflict of interest, how that's properly reported, how it's properly put into the minutes of your meeting. Make sure that you have good meeting minutes to document the fact that you did think through issues, that you did either consult experts or read the report or ask the right questions. Again, in the first episode of this series, we talked about the business judgment rule. It is a powerful defense to a board of directors, but it loses all meaning if you haven't met those 5 conditions. And last but not least, buy insurance. And again, I don't want to suggest that insurance should be your backup plan. Instead of doing 1 through 9, you should just have an insurance policy and you can do whatever you want. Certainly not. But it is very important that if you have to respond to a cyber breach, you have insurance that helps you weather that storm, gives you the right resources you need. And a D&O policy will make sure that you get in contact with a claims person who can shepherd you through issues and get you to the right lawyers or consultants or experts to make sure we can minimize the exposure to the organization. And most importantly, make sure that the organization is not disrupted as a result of the claim being brought against it. And so with that, I thank you for your time, and I hope this was helpful, and please feel free to reach out should you have any questions.
All right. Thank you very much, Kim, and thank you for to our listeners. We hope everyone has found this information valuable. If you have any questions, feel free to reach out to me. My contact information is here on the slide. And goodbye. Everybody have a great day.